It is Tuesday. It's April 29th. We are in the Commonwealth of Massachusetts versus Karen Read, day 6. Yesterday was yet another half day for the jury, but a full day for us because the ARCCA experts were on the stand for a voir dire after the jury was excused at the lunch break yesterday. We got through witness 11 partly. We got into Ian Whiffin's testimony. If you watched the last trial, he is the Celebrate guy. I thought this direct examination came in much more clearly than his last direct examination, but the questioning is more clear. There are definitely things about Attorney Brennan's style that are not my favorite, but his questioning is much more clear and the direct examination comes in much more clearly. And throughout the direct, I was saying, I hope they take the cell phone temperature from John O'Keefe's phone and the location data from Waze and the movement and activity data and put it together in a timeline. And they did that. And when we ended the day with the jury yesterday, that's where cross-examination was picking up on that timeline and what was on the timeline and what was not on the timeline. I'm very interested to see where we get this morning with cross-examination. Attorney Alessi is seeming to be the attorney that's going to be handling the experts, which we guessed from pretrial motions. And then after we get into this cell phone data, are we going to go to Karen Read's cell phone data next? Or are we going to go to who's at the waterfall? Where do we go next? Because last time the order was very clear from Adam Lally. I don't think it was nearly as strategic as this, but it was clear. And it was the first responders on scene, then first law enforcement on scene, then when John O'Keefe went out for the night, then everybody at the waterfall. It followed in groups of witnesses. This is telling a story through the witnesses in the way that the story needs to be told to the jury, not necessarily in just grouping the witnesses together. So with all of that, are you ready to go to court? Law nerds,
bring the jury.
Are you ready to go to work?
Excuse me. This is your experiment. When did you do test scenario 1, approximately, the date?
It's a good question. It was
only experts can do experiments.
Sometime probably in December last year.
You didn't date?
Sorry,
in December last year, I believe.
December 2020.
You didn't
Correct.
date when you did this?
What you did here was you took the phone, you put it inside a freezer. What was the temperature of the freezer?
I actually don't know.
But it was
What?
a freezer.
It was freezing. Yes.
At that temperature, just above freezing, you've got a...
Sorry, that's below freezing.
I'm sorry?
It's below freezing.
What is freezing in Fahrenheit?
Don't know, but it's 0 degrees Celsius.
Right.
And it was -5 degrees Celsius at the time.
Right, but would you agree that, and I want to be fair to you because I know you use Celsius more
What
than
point in time are we
Americans
talking
use
about?
Fahrenheit. But would you agree that...
Also, I don't disagree with my teen who keeps arguing that metric is superior. He's like, right, shouldn't freezing be 0? I understand, but sir.
32 degrees Fahrenheit is the freezing point in Fahrenheit?
I honestly wouldn't know.
Okay, fair enough.
I don't think the point being made here is whether or not -5 is below freezing. -5 is below 0. That would be below freezing. The damaging answer is, I don't know. That's the damaging answer. It's not the fact that he's looking at Alessi going, actually, it's below freezing. And Alessi doesn't address that it's below freezing. He says, but do you know what it is in Fahrenheit? And the guy's like, well, the jury has it up on the thing. Again, I don't know is the problem. We are at the lunch break of day 6 of the Commonwealth versus Karen Read retrial. The same witness has been on the stand all morning. And despite what I thought, and like 90% of you in the chat thought yesterday, the lawyers did not start with needing to see the judge this morning. They just got right into the jury coming in and right into the testimony of Ian Whiffin from Celebrate. We had an extensive cross-examination. I think there were points of the cross-examination that were very precise, very impactful, and very effective. And there were parts of the cross-examination that were not that at all. I think what's going to be hard for the jury at this point is they don't have the context. But some of what the defense was doing was laying the groundwork for future witnesses and future arguments. And I think that was done really well. Nailing down the timing that the defense wants to highlight, bringing up that after 12:30 a.m., when the phone took, I think it's 12:30 a.m., but when the phone took those 36 steps, that's roughly 84 feet, according to Apple. And then that measurements were taken from the flagpole in the front of 34 Fairview to the door, and that measurement was 74 feet. Those, I think, were important bits of testimony. We got into more about how this expert did his experiments with regard to the battery temperature, putting it in a freezer. And at one point, when Alessi asked, well, what was the temperature of the freezer? And he said, well, I don't know. I'm like, you put the phone in the freezer and you watch the temperature on the phone go down quite quickly, but you don't know what the baseline temperature of the freezer was? And he's like, I didn't think it was important. In redirect, we got back to that he was looking for whether or not environmental factors impacted the phone. If you put it in the freezer, does the battery show that it's colder? If you take it out of the freezer, does it show it warming back up? He said he was looking for those patterns. But I also don't think it's a good look when you were saying, well, I didn't check to see what the temperature was in the freezer. So we will see. We are now in redirect, and we have just gotten to Attorney Brennan saying, well, what kind of other tools or programs do you use to evaluate this information? And have you written your own tool? And will you show us your tool? Will you describe your tool for us? And Brennan has asked to do a live experiment in the courtroom. We saw that last trial. I didn't think we were going to see that this trial. I thought we were just going to go by the PowerPoint, but no, it looks like after lunch, we might see that live experiment of how the tab marks the time. And yes, we got more into the time of whether or not the Howe's long search was at 2:27 or whether that is the timing of the tab. And we heard a bit of explanation from Ian Whiffin deep into the redirect about why Celebrite changed the way that their printouts read, because it was confusing and it was causing confusion. Is the jury still with them at this point? I don't know. It was a long morning. There were points of cross that were good, and then there were points that got lost. There were points at the beginning of redirect that were good, and then there was points that got lost. How much of this will be taken away when we get into other testimony? I don't know. But will we be able to see the jury check back in with other witnesses? Maybe. Will we see the defense arguing the things that they nailed down in this cross? I imagine we will. And will we see the prosecution doing the same? Maybe, maybe not. But we did also see Alessi get admonished by the judge at sidebar for talking about the first trial in his testimony. And while witnesses are generally advised to say prior proceeding, the attorneys are too. And it was very interesting seeing Alessi say, well, in the first trial, and the judge is like, just sidebar. And then he came back and very clearly said, in the first proceeding. I was surprised with that from him. The prosecution didn't object to it and make a big deal about it because I think it highlights that it's an issue. But the court did pull Alessi to sidebar, and you did see him being very careful when he came back saying, in the prior proceeding. The jury is not told about the fact that there was a first trial because they are not given the information about what happened at a first trial. They shouldn't know that it was a mistrial. They're not supposed to know all of that. There is information that the jury's not given. They're not given everything. They're given proper legal evidence and testimony. And that is one of those things that is outside the purview of what the jury knows. The shit's out of the horse now. Will it be the biggest deal to them by the time we get to some of these other witnesses? I don't know. Or will the jury sit there and be like, huh, now I understand why there was a first trial, because they know now and there's not much you can do about it. If the prosecution had done it, would the defense have asked for a mistrial? I don't know. It depends on how the defense views what the jury might assume from that information. If the jury assumes it was because the defense did something, then it might not be good for the defense. If the jury assumes that it's because the prosecution did something or because the evidence wasn't strong enough, then it might be good for the defense. But you can't really know what a jury is thinking or might assume because you just don't know how they will fill in the gaps.
When they first arrived, did you see them?
Yes.
Where did you see them coming from?
I saw them walk in.
When they walked in, did you react in any way?
Yes, I was happy to see them.
Why were you happy to see them?
Because I loved John and I liked Karen.
So you were happy to see John?
Yes, very.
You were happy to see the defendant?
Yes.
So after we finally finished with Ian Whiffin's testimony and the live demonstration in court of the tool that he created that he provides for free so people can use it to do their own experimentation, the Commonwealth called Jen McCabe to the stand. And when the court broke for the day, we were to the point of Jen McCabe's testimony where she was saying that she was doing chest compressions on John O'Keefe in the snow. So we are just getting to 34 Fairview and what's going on. And it is hard not to juxtapose her testimony with her testimony last time, because it is one of those moments in the last trial that stuck out very much. However, if the jury is sitting there fresh as they should be and have not seen this trial, I think her testimony in direct examination came across very clear. I think her testimony was much easier to follow than last time. Brennan's questioning was much better, though there are definitely moments that Brennan will bring in emotional questions and a little bit leaning into the drama of, and then what happened that changed everything. And as we are getting to the point in her testimony where they're at 34 Fairview, the chat read her testimony as very contrived. I don't think the jury will read it that way. It's hard to read her testimony, especially after seeing her last time and knowing that there are changes to her testimony, which will come up and cross, because there are things I'm like, wait a second, I have not heard that before. But at this point, we have not gotten to cross-examination yet. And so if the jury is sitting there listening and knowing that she is friendly with John, knowing that she is friendly with his niece, they are going to feel for her as she is talking about realizing that it's him in the snow, that Kerry is brushing the snow off of his face, and she's realizing that that is her friend. How the jury will feel about it after cross-examination may be different. We're just not there yet. At the end of the day today, the testimony was clearer, it was less explanatory, and I felt that it was less forced. I think it has read much clearer, and I think a lot of that is because of the style of the questioning. The questioning has been much more pointed and direct, and her answers, it seems to me that she has been told to answer just the question that is asked, which is appropriate. And she, at times, you could see where she was straining to add more information. The over-explanation was a problem for Jen McCabe in her direct examination last trial. And it seems very much that Brennan is trying to rein that in so there is not over-explanation. And still at times there is moments of that, but it reins back in. I am interested to see how much cross-examination there is, because there was information in this testimony that was not consistent with what we've seen before, but we're just not there yet. And the jury does not know that yet. They're left at the end of the day with a woman who is seeing her friend's face be uncovered in the snow, trying to do CPR, saying that it felt odd trying to do CPR, that it felt weird, which if you've never done CPR before and they haven't asked, I imagine would feel weird. And we haven't heard the 911 calls. I think what the prosecution has done well in ordering these witnesses is in Ian Whiffin's testimony, in his timeline, we saw a timeline of when Jen was texting back and forth with John O'Keefe. And now we are hearing Jen's side of texting back and forth with John O'Keefe. And we've seen some of the videos at the waterfall that were really hard to see. The exposure was overgained. I don't know if that's the lights in court or if they tried to clean up the video and just missed, because there were parts of the video that were very hard to see. But we got into some of the video from the waterfall with the timestamps, but we didn't get into it in depth. There wasn't like this rehashing of the video. It was just, okay, at this time you see these people here, you see those people there. We will see what happens tomorrow, because I have a feeling we have a bit more of direct examination to go before we get in cross, and the cross examination I expect will be incredibly lengthy.
Your Honor, in light of yesterday's hearing with the ARCCA witnesses, the Commonwealth is going to ask the court to preclude the ARCCA witnesses from testifying both about any new testing and any new opinions, and secondly, from testifying about their original opinions turned over in a report prior to last year's trial. To be brief, what we learned or confirmed is that we do not have all of the discovery or communications. There was a court order for the ARCCA witnesses to provide Your Honor with all of their information, phone records, text messages, communications about this case. Instead of providing their information to the court, they instead chose to send it to the defense, and then it was summarized and provided by the defense to the court and to the Commonwealth. It appears to me that is not in compliance with the court's order. What we learned during the hearing yesterday is that Dr. Wolf admittedly destroyed over 100 text messages. Now, he mentioned that he changed phone carriers, but then later admitted that he actually intentionally, for no apparent reason, destroyed the text messages in this case. And so what is left for Your Honor to look at is a summary of phone records from the defense and ARCCA's information that is passed through the defense to the court. You do not have the text messages. You do not have the content of the text messages. There is no summary of the conversations, dozens and dozens of calls between the defense and the experts. It is difficult to believe that all of those text messages and all of those phone conversations dealt with simply logistics. In fact, we later learned during the questioning of Dr. Rensselaer, there is much more involved than simply logistics. But to get back to Dr. Wolf, he did not disclose to the court that he was communicating and having conversations on Signal. How odd. An expert using Signal. Never used it before. Dr. Rensselaer said would not use Signal, never use Signal. But Signal, as we know, is an application that does not create a record of communications. Dr. Wolf maintained on his direct that everything he did was logistics, even when we showed him the direct examinations with comments that asked for input from the defense to questions in a way that would be advantageous to the defense and to thwart the Commonwealth. Dr. Wolf actually still continued to testify that that was simply procedure and logistics, never admitting the fact that there was, in fact, conversations or information exchanged about bettering the presentation for the defense. Inevitably, I asked him about the sequestration order and how evasive he was. You simply have to compare him to Dr. Rensselaer, who was quite candid. An hour or 45 minutes with Dr. Wolf, difficult getting a straight answer. Dr. Rensselaer told us more in 5 minutes than Dr. Wolf told us his entire examination. And what we unfortunately learned is that during the trial, when this court had a sequestration order, information was being passed to the experts about witness testimony, in this case, unknown to the Commonwealth, unknown to the court, information, particular information, not general information, witness testimony, issues in the case. We have no idea who is deciding or identifying the issues and who the advantage is given to in describing those issues. But that is witnesses being prepped through an intermediary. So we know the Department of Justice, at least, is violating the order, helping the witnesses along, and then they testify unbeknownst to the Commonwealth that they have this information, but obviously is reflected in the testimony. In addition, I provided some clips to Your Honor for review.
Yes, do you want me to mark these as an exhibit?
I do.
I did have the opportunity to look at them.
I suggest that the relationship was not resigned to mere logistics. And so from that subterfuge, what we stand with today is that we know that the witnesses were well prepared. We know that there was not true independence. And what we know is that they are refusing to provide the necessary information to support their original opinions that they gave at the first trial. They cited that it was a protective order. Perhaps it is. That has nothing to do with the issue. By calling the ARCCA witnesses as their witnesses, they then have the obligation to comply with Rule 14. Unlike the first trial, where the Commonwealth had no ability to do any testing, review, vet the reliability of the information, properly prepare for cross-examination, this trial, that should not occur. Just because it happened last trial and the Commonwealth was disadvantaged does not mean it should happen in this trial. And that is precisely why I began moving for discovery in this case early on. Inevitably, if these witnesses cannot provide information because it's under a protective order, it may not be the defendant's fault in its inception, but it is their problem and difficulty because they chose to hire the ARCCA witnesses. They could have chosen any witnesses they want. Rule 14 is not obviated because they made a strategic decision to call the ARCCA witnesses. So now going into this trial, even Dr. Rentschler admitted that an expert should have time, in their opinion, a month or more, to review the raw materials. It's not enough simply to have a report, as Attorney Alisi preached during his argument. We should have the opportunity to go through the raw data, the history, the videos, determine whether there's any failed testing. We don't have that benefit. And so my position has changed, that those early opinions should not come in because we have no ability to fairly cross-examine. As for the new opinions, the report may not be done till May 7th. We are in the middle of trial. Concedingly by the defense, or at least their witnesses, it takes a month to go through the discovery. When I filed my motion on the eve of trial that we would be unable to prepare or we would want a continuance in this case, I appreciate why this case wasn't continued, but I knew, given our scheduling, our experts will not be able to look at this material. Our expert is away until after the first week of May. He is going to be testifying shortly after. He will have no ability to digest this enormous amount of materials, vet whether it's accurate or not, conduct tests to combat it if he thinks that it's inaccurate or unfair. And so the discovery violations, regardless of the state of mind, are upon the defendant. There is no exception that you used ARCCA witnesses. There is no exception that you hired somebody that used to be under a federal protective order. They chose them, and I would suggest it seems strategically. When we noticed we'd have new experts in October, the defense from past experience, and probably other experience, but we know from this case, knows the process. They would have to file a TUI letter and wait for a response. And yet they waited until February to seek permission, which then extended their permission past February into March, and then they didn't even start the review until late March. And so it's fundamentally unfair. We should not be placed in the position of cross-examining experts without the fair ability, as any participant, defendant, Commonwealth, any participant would have in a case, to consider and then to rebut. And so for that reason, I ask you to exclude both the new opinions and new testing, and also to exclude the earlier opinions that we will never, at this point, receive the proper discovery with to prepare.
All right, thank you. Mr. Alessi, I only have one question for you. So would you stand, please? You're arguing this, right? This was your motion. So my question is, how do I reconcile the fact that 100 text messages were deleted by counsel? And we heard yesterday counsel's preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15? I don't see how you reconcile that, where all correspondence related to the matter, whether in physical or electronic form, must be saved for 10 years minimum. How do you reconcile that? How do I reconcile that?
Should I go to the podium?
Right there, and I expect a short answer.
The short answer, Your Honor, is the rule that you're citing has absolutely no applicability to this proceeding. Can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Alessi, you know what? You're going to win this, so why don't you just let me make my ruling, okay? So I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So I'm going to allow the ARCCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination. And I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th. And I know that's late. And if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand. And I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct, and no more nonsense. Let's just try this case. All right, that's it. I'll see you tomorrow.
I am very surprised that when we got to the ARCCA arguments today, after the voir dire, that at the end of the ruling, the court is not just letting it in, but letting it all in. So Brennan argued what I thought he was going to argue yesterday. And when Brennan started going down the line of questioning about when ARCCA was out of their contract with the federal government in June 2024, it seemed clear to me that the argument from the Commonwealth is, Your Honor, the defense could have done this sooner. They waited, and they waited on purpose so that we would not have time to evaluate it. They waited to even ask until February. They couldn't even get appointed until March. And then the reports are coming in the middle of trial. There are a lot of judges who, on that information on this new trial, might have kept that out and said, you're right. They could have hired ARCCA back in June or July of 2024, but they waited. I think the flip side to that is that the defense didn't have the Commonwealth's reciprocal discovery with the underlying data and the full underlying data until just last month. So on the rebuttal part, I think it would have flown if they are coming in as rebuttal witnesses, which it seems that they were planning to just come in as rebuttal witnesses. And the judge threw the entire fucking door open and said, well, I know you were going to have them come in as rebuttal witnesses. They can testify about all of it. They can literally mention it all. ARCCA said, we've only been brought in to testify as rebuttal witnesses. They said that yesterday, and the court said, nah, you can give your opinions from last time and you can come in as rebuttal. More than what the defense asked for, which surprises me, because I think the Commonwealth yesterday did a good job of illustrating how important the underlying raw data is, and the fact that they don't have that underlying raw data in this case, cannot turn it over, cannot get it, and won't get it. She could have restricted ARCCA for, at this point, not turning over the raw data and kept them to a rebuttal witness, which would have fallen under what the defense was asking for. And she didn't. She said they can talk about all of their findings. That is a broader ruling than what the defense asked for. And I think Brennan is probably sitting there going, not only did I lose, but I lost shit I thought I couldn't lose. And the Commonwealth is going to be pissed about that, because the judge expanded what ARCCA can testify about, which is a very big ruling for the defense. I don't think a single defense attorney on the defense team gives a shit that she called it an ambush or said whatever. She said, this ambush that has been set upon you to the Commonwealth. The defense doesn't give a shit because they won a huge motion in their favor. Okay, Your Honor, say it's reciprocal discovery that we violated, but they are going to bring ARCCA in for more. And I understand where the Commonwealth is coming from. In the first trial, is there as much they can do? No. Could the defense have reached out to ARCCA in the summer and brought that in and tried to get to more of the underlying information? I don't know. The Commonwealth thinks they could have. The difficulty with having a federal investigation is that there are things that will be sealed, and the DOJ is not giving you what is sealed. It doesn't matter if you're the defense. It doesn't matter if you're the prosecution. I suspect if the Commonwealth, and given ARCCA's findings, that's not going to be the case. But I suspect if the situation was reversed and the Commonwealth wanted to bring in ARCCA because it was good for their case, and they didn't have the underlying raw data, that the court probably would have kept it out, finding that it unfairly prejudices the defense. So when we're looking at how the court is ruling, I think that this ruling would have gone differently had the prosecution been the one seeking to bring in an expert without turning over the raw underlying data. And that is why the Commonwealth is so frustrated. But if Karen Read is acquitted, you know what? The Commonwealth can't appeal it and say, we should have gotten more discovery. There's nothing they can do. If Karen Read is convicted, this isn't going to be an issue that the defense brings up because the court expanded what their experts are allowed to say, even in the face of discovery violations. The court said, hey, the voir dire is your resolution to the discovery violations. And then the jury can decide if they find these experts trustworthy or not. I can see a lot of judges that might have said, take it up on appeal. You're not turning over the data. You're required to. You had time to do it, and you can't bring it in. Wow. So the Commonwealth is going to be livid with that ruling. And the court, I think, to the surprise of many, expanded a very large ruling in favor of the defense. I will say with this judge, there are times that she has stronger languaging for the defense, but every time it comes down to, I don't know, the rubber meeting the road, those big motions, she has ruled in favor of the defense on most of them. And that, again, is one of the things we heard this judge said, this defendant deserves a fair trial. So ARCCA can testify fully. Not all judges would have done that. We're going to see what happens, but she also didn't say ARCCA needs to give the Commonwealth their report before May 7th. She said, you'll get it when you get it. Wow. Wow, wow. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.